Good evening, ladies and gentlemen. Thank you very much for being here at this event organized by Studio Generale with the collaboration of the Engineering Solidarity Palestine, represented here by Begum Sari. My name is Filippo Santoni. I'm a professor, associate professor in ethics and philosophy of technology here at TU Delft. In the past months, you may have heard a debate on top of the tragic news coming from Israel and Gaza. You may have heard a local debate about what the role of universities should be in discussing and talking about this conflict. And you may have heard different positions about that, some people claiming that university should not get involved in this debate, especially technical universities who should allegedly be neutral in talking science and technology, but not politics and history. Other people have said that no, that it's the opposite. As educational institutions, we have not only should be allowed, but we have an obligation to engage in this discussion. And I personally very much endorse this latter position. And so I'm very grateful for Studio Generale and ESP for organizing events like that and for inviting me as a moderator, because I really endorse the necessity of talking these topics openly and obviously as a university to talk these topics in a well-informed way, in a way that allow people to make a well-informed opinion on these things. Then we will keep on disagreeing, but at least we will have some substance to discuss. In that sense, I'm very happy to have three very competent and distinguished speakers tonight. I will present them in the order of their presentations. So we'll have Vukusic, Marten Zwanenburg first, professor of military law at the Netherlands Defense Academy and the UvA, University of Amsterdam. Welcome, Marten. Then we'll Vukusic, assistant professor in international history at Utrecht University and visiting research fellow at the Department of War Studies, King's College London. Welcome, Eva. And then we have Dirk Jalvingh, who is a policy advisor at Oxfam, Novib. Welcome, Dirk.
Thank you.
Before giving the words to our speakers, just a bit of planning of the evening and rules for this event. We will have 15 minutes presentation for each of the speakers, followed by ample time for discussion, Q&A. I will take questions from the audience. So I will kindly ask you to wait until the end of the presentation to ask these questions. I say that because I know that this, as we said in the beginning, these topics are sensitive, can make people uncomfortable. You may strongly disagree with what you hear. You may, whatever reaction these talks can trigger in you, we really strongly ask you to wait until the end of the presentations, and in any case, to respect each other in the discussion and to be aware that any Islamophobic, anti-Semitic, or otherwise offensive, discriminatory language will not be tolerated. Okay, that said, I think it's about time to start listening to our presenters, and so Marten Zwanenburg, the floor is yours. Thank you.
Thank you very much, Filippo. And thanks to the organizers of this event for inviting me to speak. I probably should disclose that I studied at the University of Leiden, and there's a friendly rivalry between the University of Delft and the University of Leiden. And I probably, when I was a student, would not have ever expected to be speaking at Delft University. So I'm glad to be here and to be able to do that. As Filippo mentioned, the topic that we're addressing today is a sensitive topic, but it's also a very important topic and one that I think we should address in a courteous manner, of course, but I think it's important to talk about it, and it's important to talk about the conflict and international law and what international law has to say. And I also think that the law offers us a language in which we can talk about the conflict without this becoming immediately having to become emotional. So I think it's the law can help us in offering a common language that we can all use. So for my presentation today, I thought I'd address three themes. The first theme is the law that applies in the conflict, to the conflict, and in particular international humanitarian law. So what are the rules that actually apply? What is the legal regime that applies? The second theme is applying the law to certain recent events. So I've selected a few, one not so recent, two more recent events to talk you through how the law could apply to those events, what the law has to say. And the third theme has to do with ensuring compliance with the law. How do we do that? Whose responsibility is that? And in that context, I will also briefly address the recent judgment by a Dutch court on the export of F-35 parts, which I'm sure Dirk-Jan will also address. So let me start with my first theme, the applicable law. There's a famous saying by Cicero that silent. I have to check. Silent enim legis inter arma, and sort of English translation is in times of war the law falls silent. And I think for a long time that was the legal position, that during the war there were not so many rules. But certainly nowadays that's no longer the case. It's now generally recognized that during an armed conflict, during war, the law applies, and in particular the branch of international law that we call international humanitarian law, often abbreviated as IHL, applies. And the main treaties that form that law are the four Geneva Conventions. I'm sure you've all heard of those, and two additional protocols to those conventions of 1977. And those treaties have essentially two objectives. The first objective is to provide rules that protect persons who do not or no longer participate in hostility. So think, for example, about civilians. Think of prisoners of war who are no longer participating in hostilities. And then the second objective of these treaties is to regulate the means and methods that the parties use to fight each other. So think, for example, about the types of weapons that they may use, or particular methods. I'll come to talk about the method of perfidy, for example, that they may use when they fight each other. Now, it's important to remember that IHL has different regimes for what it calls international armed conflicts and non-international armed conflicts. International armed conflicts are conflicts purely between states, so all the parties are states. Non-international armed conflicts are conflicts in which at least one of the parties is not a state but a non-state actor. And that distinction is important because, at least as far as treaty law goes, there are more rules that apply in an international armed conflict than apply in a non-international armed conflict. And then there's also a specific regime that is part of the law of international armed conflict, which is the law of occupation, which is also arguably relevant to Gaza, which regulates the specific situation of belligerent occupation and provides some additional rules that essentially regulates the relations between the occupying power on the one hand and the population of the occupied territory on the other hand. Now, when we try to apply that theory to the case of Gaza and the conflict between Hamas and Israel, lawyers have different views on which regime applies. And that has partly to do with different ways in which lawyers and others, of course, look at Palestine and whether Palestine is a state or not. You may be aware that the Netherlands has not recognized Palestine as a state, but many other states have. It also has to do with the question whether Hamas can be seen as acting on behalf of a Palestinian state, if you do recognize that there's a Palestinian state. And it also has to do with the question whether Gaza was or is occupied. So there was a long-standing discussion after 2005, when Israel disengaged from Gaza, withdrew its troops, whether Gaza was still occupied by Gaza. And the UN and the International Committee of the Red Cross, for example, said yes. Israel and some others said no. And the answer to that question largely revolves around the question whether, when a state no longer has troops in an occupied territory but is able to control what happens there in other ways, whether that is still sufficient to say that that state is occupying Gaza. Now, my own view is that what we're dealing with in Gaza is a non-international armed conflict between Hamas and Israel. So it's a non-international armed conflict, but against the background of an occupation by Israel, at least of certain parts of Gaza at the moment, where Israel exercises effective control over at least certain parts of Gaza. And that brings me to the second theme of my presentation, which is trying to apply the law to certain incidents or certain events that occurred during the conflict. And I've selected three. The first is the attack by Hamas on the 7th of October, which was the trigger for the conflict as we now know it. The second, and the other two incidents or events, or if you will, have to do with Israeli actions. So starting with what happened on the 7th of October. And I think there's really no doubt that in that case, the attack by Hamas constituted violations of international humanitarian law. The attack was largely committed against civilians, and a fundamental principle of IHL is the principle, so-called principle of distinction, which means that parties to the conflict must distinguish between civilians on the one hand and combatants or fighters on the other hand, and they may only attack combatants or fighters, and they may not attack civilians. So clearly, the attack by Hamas, which killed large numbers of civilians, was a violation of the principle of distinction, which applies whether it's an international or non-international armed conflict. So that was clearly a violation. Of course, the attack on the 7th of October also led to the taking of hostages. And IHL prohibits the taking of hostages. It doesn't provide a definition of hostages in itself. There's one, if we look at other sources, and in this case, the source that I've looked at is the statute of the International Criminal Court, and the elements of crimes that the court uses. Then we see that hostage taking is defined as where a person has been seized, detained, or otherwise held hostage, and where the perpetrator threatens to kill, injure, or continue to detain that person. And the perpetrator must do that with the intent to compel a state to act or refrain from acting as a condition for the safety or release of that person. So you have to hold a person, but also hold a person to try to compel a state to do something or refrain from doing something. And if we look at what Hamas has done, I think it's quite clear that Hamas has used the hostages to try to get Israel to either do things or not do things, including agree to ceasefire. So I think in this case, it's quite clear that that Hamas has committed the violation of IHL of hostage taking, which, by the way, is also a war crime. The second incident that I would like to discuss has to do with something that happened in January of this year, where Israel and Hamas concluded an agreement where Israel agreed to let the consignment of medical stores into Gaza, and in return, Hamas agreed to give some of that medication to the hostages. And that, in principle, of course, I would say is a positive development. It's great that the parties can agree on something and that this leads to persons receiving medication. But from the perspective of IHL, it's actually quite odd. Because, as we discussed, under IHL, it's prohibited to take hostages. And at least whenever someone is detained by a party to the conflict, they must be treated well and receive all the medication that they need. So Hamas, in the first place, since hostage taking is prohibited, should release the civilians that it's holding. And so that a priori is already a violation of IHL. On the other hand, Israel has an obligation under IHL to let humanitarian goods that are destined for the civilian population, even if it's the civilian population of the adversary, to let them through. There are some limited exceptions to that obligation under IHL, but in my view, they don't apply in this particular case, or at least not on a general basis. So also there, you could say that it's great that this agreement was concluded, but Israel had the obligation to let the medication through regardless of whether there was an agreement or not. The third incident I'd like to discuss, and that's also the final incident that I will discuss, is the raid carried out by Israel in the Ibn Sina, and I'm not sure if I'm pronouncing that correctly, hospital in Jenin on the 29th of January of this year. And you may recall in the news that Israeli personnel, apparently Shin Bet personnel and police, raided a hospital in Jenin, dressed as doctors, nurses, and civilians, and then shot 3 men who were in that hospital, at least one of whom was allegedly being treated for wounds that he had sustained in a previous Israeli airstrike a number of weeks before. So that raises the question of whether this was a violation of the prohibition of perfidy, which I already referred to before. Under the prohibition of perfidy, it is forbidden to lead the enemy to believe that they have to accord protection to persons and then abuse that confidence that you've created to kill, capture, or injure the adversary. So you're abusing the confidence that you've created by raising the idea that you're protected under IHL. And if you dress up as doctors or nurses or civilians, which are generally protected persons under IHL, then you're creating that impression. And then if you kill someone doing so, then very arguably that was a prohibition, that was a violation of the prohibition of perfidy. Another possible violation of IHL that we're dealing with here is the killing of persons who are hors de combat. So as I said, there's a distinction in IHL between civilians on the one hand and fighters or combatants on the other hand. But those fighters or combatants, as soon as they are placed out of action, as they're wounded, sick, can no longer use force, then they also must be protected. So if these 3 men who were killed were no longer able to defend themselves, then killing them would arguably be a violation of the prohibition to kill persons who are hors de combat. And that brings me to my final theme, which has to do with ensuring respect. And Dr. Vukusic will talk about that a little bit more in detail, but for now, I'd just like to make some general remarks. So essentially, there are 2 ways in which there can be responsibility for violations of IHL. One is a state being held responsible under the so-called law of state responsibility. If a state breaches one of its international obligations, and that violation is attributable to the state, so we can say that there's a link between the person committing it and the state that's sufficiently strong, then the state is responsible under state responsibility as such. But of course, if you want to hold a state responsible, then probably you want to have some authority pronouncing on that, and there there's not always a forum available to actually hold that state responsible. So that will be also addressed more in detail in the next presentation. The other possibility, which is not an alternative but can run in parallel, is that where individuals commit war crimes, and war crimes are certain serious violations of IHL, so all violations of war crimes are always violations of IHL, but not all violations of IHL are war crimes. If a person commits a war crime, then he or she can be held criminally responsible based on war crimes. And that can be before either a domestic court or an international court like the International Criminal Court. As I said, it's not always obvious that there's a forum available to actually make that responsibility concrete. And against that background, I think it's very important to underline that there is also responsibility for other states, so states that are not parties to the conflict, to make sure that the parties to the conflict respect international humanitarian law. In particular, one article in each of the 4 Geneva Conventions, Article 1, provides that parties to the Geneva Conventions have to not only respect, but also ensure respect for the conventions. And there's some controversy on what that ensuring respect actually means, and the controversy centers mostly around the question whether it means that you have to ensure that your own armed forces, but also your own population, for example, respects IHL, or whether it also has a so-called external element, meaning that as a state you have to also make sure that other states and organized armed groups, parties to a conflict, respect IHL. There are different views. My own view is that to ensure respect means exactly also that states have to have a certain responsibility to ensure that other states and organized armed groups respect IHL. Of course, what they have to do to fulfill that obligation depends very much on the means that they have, and the means that they have will also depend on their relationship with the particular actor. So, for example, the US has very close ties with Israel, so it has more possibilities to ensure that Israel respects IHL than many other states. A brief illustration of how this obligation can work in practice is the judgment by the Court of Appeals of The Hague on the 12th of February this year, which we'll probably hear more about from Dirk. So very briefly summarizing that judgment, the court said that within a week, the Netherlands had to stop exports of parts for the F-35 jet fighter to Israel because there was a serious risk of violations of IHL being committed by Israel using those parts of the F-35. And what's interesting is that in the judgment, the court, among other things, also relied on that obligation to ensure respect for IHL. And I'm just going to quote what the judgment said. It said it would be irreconcilable with that obligation to ensure respect, were a state to be able to close its eyes to serious violations of IHL and would refuse to draw consequences for a license for the shipment of arms to a state committing such violations. So the court said that obligation to ensure respect means that you have to stop exports if there is a serious risk of violations of IHL. Now, of course, the Dutch government has said that it will carry out the judgment, but also that it has also lodged an appeal to the Supreme Court against this judgment. So it will be interesting to see what the Supreme Court will say, also about the obligation to ensure respect. But I do very much hope that the Supreme Court will uphold that obligation, that external obligation under Article 1 of the Geneva Conventions to ensure respect, and say that, yes, there is an obligation also for the Netherlands to take measures to make sure that Israel and other parties to the conflict respect IHL. And why is that important? Because I think it would underline that the responsibility to ensure respect for IHL is not just a responsibility for each individual state, but that it's a responsibility for the international community as a whole. And I think that's something that needs underlining, where it seems that it's so difficult to get the parties to respect IHL. So that brings me to the close of my presentation. Thank you very much for your attention, and I very much look forward to the discussion.
Yes. Thank you very much, Marten, for an extremely clear and informative presentation. Before giving the word to Eva Vukusic, I would just like to inform you that the event, I should have said before, that the event is recorded, but the cameras are taking only the stage and the speakers. At the same time, there is also a journalist and photographer who is taking pictures around. So you may be featuring some of the pictures. So if you do not want to be featured, please give a heads up to the photographer. Okay, yes, you can raise your hand if you do not want to be. So please keep an eye on. Can you raise your hand again so that the photographer can see? Okay, wonderful. And in the back there. Okay, thank you very much. Eva, the floor is yours.
Thank you. I hope the audio is right. So it's an honor to be part of this esteemed panel. So before I start, I want to acknowledge the immense suffering of people within this context in the places that we are discussing, those killed, maimed, or abducted on October 7th, as well as those bombed in response, denied hospital treatment, food and clear water, and access to a safe bed and a roof to sleep underneath at night. So as we discuss in the Q&A especially, I hope remain cognizant of that because we're discussing these difficult topics from a safe distance, which is very, of course, lucky for us. So we will be talking about a place that I think is populated by people who carry a heavy burden, historically, of suffering and trauma. For the Jewish population, the Jewish Israelis, of course, from the Holocaust, and to the Palestinians from the Nakba in 1948, and the feelings of, I think, decades of what they see as neglect by international law, the denial of the right to self-determination, and obtaining the dignity and protection of statehood. So I think Palestinians especially, and that is my impression from having contact with colleagues, is that they're hungry for justice because they see themselves as being denied it. And I think much of what we tend to call the global south is following the responses by different states, especially powerful Western ones, in the past 4 months, and following how the responses now measure up against some other responses to different contexts, for example, in Ukraine. So I come to this topic as a historian and a genocide scholar, and I'm, one could say, also a client of international justice. I'm originally from the former Yugoslavia, and I was surrounded by war crimes 30 years ago. Luckily, none of them hit me and my loved ones. But I grew up in an environment that gave birth to the first contemporary war crimes tribunal, the International Criminal Tribunal for the former Yugoslavia. So I want to talk about 2 courts now in my presentation in the 15 minutes or so that I have, the International Court of Justice and the International Criminal Court, both in The Hague, and the cases that they are called to decide upon or may be called upon in the future, and what their role will be in providing some justice, and I want to emphasize some, in this utterly desperate, tragic situation. So I want to start my sort of main points by saying that international legal practice in courts may seem distant and dispassionate, and it is sometimes criticized for it. Marten was speaking about it in a way a couple of minutes ago. People ask, and I've been asked that as well, how can you discuss human suffering in such a way? But that distance and lack of passion, I think, much like Marten, I believe, is, I think, helpful, and I'll come to it in a moment. But if some of you have watched, for example, the decision that was delivered by the International Court of Justice, so the ICJ, the president of the court until recently was Joan Donoghue, and her voice as she delivered her remarks, I think, is a good illustration of this dispassionateness. So in a context of heightened emotions, I think it's really helpful to try to calmly discuss a dispute. And I think some of you may even object to me calling it a dispute. And to hear arguments about why actors are acting the way they are, and to try to determine what is and what is not lawful. So recent Israel and Palestine cases at the ICJ actually, on the other hand, also brought us quite emotional pleas in speeches that advocates made. And we even saw tears. I don't know how many of you followed the ICJ proceedings, for example, last week in the advisory opinion, and I'll come to that in a moment. But for example, the representative of the state of Kuwait was crying, and he was not the only one. So, you know, it is generally a fairly dispassionate and distant world, but not always. Legal proceedings, I would say, do allow some distance from everyday politics, if in no other way but their slowness, because they tend to play out over months and years, and the fact that judges come from various different places around the world and can be perceived as outsiders to the situations that they're trying to assess. So we can also come to some other critiques of the international justice system. For example, a frequent accusation is of it being sort of created and implemented or sort of manipulated by powerful states that it's kind of a tool of hegemony. And I'm happy to sort of discuss that in the Q&A if there's any questions. But now to come to the courts. So first, I want to start with the International Court of Justice. So that's that building that looks like a castle. It's not the other one. The other one is the International Criminal Court, and it looks like a corporate headquarters. But the ICJ, so the one that looks like a castle, was home recently to two very, very important cases that relate to this geographical space, so to Israel and to Palestine. One, what we will call a contentious case. So this is the case where South Africa brought a case against Israel, I think filing it late in December. And it relates to violations, alleged violations, South Africa said, of the Genocide Convention of 1948. And the other one is the so-called advisory opinion on the legal consequences of the occupation, which is a result of a prior request. So it predates the Gaza case prior to October 2023, of course, and it's basically a result of a question of the General Assembly of the United Nations. So I'll talk about both of these, but first let me start with the genocide case. So this is about, indeed, state responsibility, which means that at the end of the day, no one goes to jail. And the findings of this process, which was reported on extensively, will be legally binding. So the ICJ South Africa-Israel case is limited to genocide. So it's not about war crimes, it's not about violations of IHL, it's not about crimes against humanity, and it's entirely based and rooted in the UN Genocide Convention and its very narrow definition of what genocide is. So that is what the ICJ can speak about. It's not called upon to speak about anything else in this particular case. It's about genocide. So let's just kind of run through a little bit what is the definition of genocide. So it comes from Article 2 of the Genocide Convention of 1948. And I just want to read it out, basically, because, a lot of states just basically copy-paste this definition, and it's likely that if you have a genocide definition of your own legislation in your own countries, it's probably this one. So in the present convention, genocide means any of the following acts committed with intent to destroy, and that's an incredibly important part of this, in whole or in part, a national, ethnic, racial, or religious group as such. It might seem non-consequential, but lawyers can argue for decades about what as such means, or what is a part, and lawyers have discussed it extensively in the past decades. So some of the acts that we're talking about, pretty obviously, killing members of the group, causing serious bodily harm or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and finally forcibly transferring children of the group to another group. So these are the acts that may constitute genocide. Genocide is, contrary to popular belief, not about numbers. It doesn't matter, strictly speaking, for the definition that 30,000 people, from what we know, recent sort of information coming out of Gaza, are killed in this situation. So it's not about numbers. Of course, genocide or cases of genocide that have been ruled upon are often instances where many people are killed, but that in itself is not a factor, strictly speaking. So it's about basically targeting a person as a member of a group. And, for example, a distinguishing feature of a murder as a genocide as opposed to a murder as a crime against humanity or war crime is this intent, the intent to destroy. This is really that crucial part. So for the ICJ to ultimately rule that this is a case of genocide, the actions being done with this special intent must be the explanation for why Israel is doing what it's doing. So the bar is extremely high. Many experts argue that it's actually too high, and that it may be so high that it is, in fact, very, very difficult to reach. So that is the critique. So some questions that appear in relation to the South Africa-Israel genocide cases. Why South Africa? Of course, they're not involved, strictly speaking, and this is, again, something that Marten was talking about. It comes from this rule that's called erga omnes partes, that basically says that all states have an obligation, not only kind of the injured states or involved states. So South Africa, as a signatory or other signatories, may bring cases. There's other examples of this outside of the Genocide Convention. For example, the Netherlands is involved in a torture case in Syria, also as kind of through the same idea that it is such a violation that it offends everyone, and we as kind of the world community need to do something about that. So that's sort of the idea. Politically speaking, South Africa, of course, has strong ties with the Palestinian resistance, and this is a decades-long relationship. There have been critiques against South Africa in this particular case because it doesn't exactly have a squeaky clean record when it comes to cooperation with international institutions, when it comes to things like this. So, for example, former president of Sudan some years ago visited South Africa, Omar al-Bashir, who was under indictment of the International Criminal Court. And of course, that is a problem. You're not supposed to do that. South Africa also maintains fairly friendly relationships with Russia. So, it kind of problematizes some of the idealizing that may go on when it comes to the reasons why South Africa raised this case. Genocide cases are generally rare at the ICJ, also in the criminal proceedings. The only, for example, instance in the former Yugoslavia that was ruled as genocide was Srebrenica, so some of you may be familiar with it. So genocide is something that fairly rarely happens if genocide finding is fairly rarely happens in court, but one would argue it happens much more out there in the world. But again, the threshold is really difficult. To prove this intent is really difficult. So these cases also, of course, carry an incredible weight. As genocide is considered to be some crime of crimes, even though technically speaking, there is no a list of the worst crimes. All of them are worst, but there is this kind of aura, and it's often used sort of as a kind of a political sort of effort to get attention, to get sort of advocacy going, because it's considered that it's somehow worse than other violations. So preliminary measures were granted, I think 6 of them. So I think one important thing also to say is that the International Court of Justice was not asked at this moment to try to rule or to try to make a decision about is there a genocide or not. So this just has to do with the fact that that's the phase where we are at. They will be discussing is there a genocide or not later. For the provisional measures stage, what was needed was a suspicion kind of plausibility. Is it plausible? Is it imaginable that what we're seeing is maybe a case of genocide? And in overwhelming majorities, and I think the Israeli judge also joined on ruling some of the provisional measures. So the overwhelming majority of the judges indeed agreed and granted these provisional measures. One of them was to kind of fight and prevent genocidal sort of speech. Another one was about access of humanitarian aid. And those are, I think, 2 that the Israeli judge, I think, joined as well. And again, this overwhelming majority is an important part of it because it gives more weight, more credibility to this decision. So basically, the provisional measures are like an attempt to freeze a situation because the court needs years to figure out what is going on and make the ruling and explain them, of course. So the idea of the provisional measures are to basically prevent things from getting worse. And Israel was also told to report, as much as I understand it did a couple of days ago, but the report is not public. So the final kind of controversy or 2 around this and misunderstanding maybe about this is about what this is about is that why the court hasn't ordered Israel to stop all military operations. Many experts said that that was not actually on the table because it's not part of the genocide convention, so to say. And generally speaking, a lot of the experts agreed that this is a very kind of a reasonable ruling. And that, I've talked to many colleagues and listened to 35 podcasts and 75 articles, and it's generally considered to be quite a, fair, balanced sort of decision. So people also ask why this was not about Hamas. The answer is really simple, because Hamas is not a state. The ICJ speaks to states, so if you're not a state, you're just not someone that they can really engage in. So for more on this, I'm happy to recommend some writing. Janina Adil Haq of Rutgers, Marko Milanovic, Una Hathaway. A lot of people have written really, really good pieces for a broader public, and I'm happy to provide some more names. On the advisory opinion case on the occupation, so this is basically from the General Assembly question. So the ruling here will not be binding, it will be advisory. And of course, some of you may know about the Wall decision also about 20 years ago now or something that was also an advisory opinion. And basically, it was about the occupation and how do policies and practices of Israel affect the legal status of the occupation. and kind of what are the consequences arising from the occupation. What I found really fascinating, and I watched it all week last week, is that 52 states intervened. Basically, that means that they presented arguments on the occupation, and I actually thought it was quite impressive to watch. I think 52 states intervening was the highest number ever at the International Court of Justice. So you have states like Slovenia, China, Japan, Iraq, Iran, Chile, Canada, UK, US, Libya, Kuwait, Malaysia, all of these states and many more acting in front of the court as if they're exactly the same. So Slovenia and China are exactly the same in front of the court. So I find that actually quite, I don't know, I watched it and some of it was actually quite moving. So the ruling is non-binding, but important because it has certain heavy, potentially diplomatic and political consequences, because you can be sure that whatever happens at the ICJ goes straight to the desks of the ministries of foreign affairs, where people discuss it and then see how states will act. So I think the present situation is one where the ICJ really, really attracted a lot of attention, and I think for good reason. So just a minute or two on the International Criminal Court, because things here are not as numerous and not as public. So this is about the International Criminal Court, so the court that is not related to the UN, so it's a separate institution, and it's about individual criminal responsibility. So here, at the end of the day, someone goes to jail or not, depending on a conviction or an acquittal. But an investigation is ongoing in relation to these events. And here, the court does have jurisdiction over both Hamas and the IDF, or whoever may be acting on both of the sides, because Palestine, of course, joined, and the court ruled, I think, in 2021 that the court does have jurisdiction. So they have been, I think, since 2021, conducting investigations. Generally speaking, criminal investigations happen behind the scenes, so we don't know many details, and that's normal about what precisely is going on. This is politically very difficult, and I'm sure I don't need to tell you that. The ICC generally struggles in bringing cases against state officials, and if they were to bring a case against an Israeli high level, or any level really, the court and the prosecution knows that there would be political backlash. So it's really important for the court to be supported, because the court, an institution, the way it is only as strong as the states backing it. They don't have a police force. They're funded by states. They can't do anything, really, without state support. Ultimately, that's going to be very, very important. And again, the Global South, I think, is also watching to see if the court will be able to indict someone who's not an African warlord, because that's, of course, the critique sort of so far. Israel is, of course, not a member, I'm sure you know, but Palestine is. Here, I think we can also discuss the issue of complementarity, because the court is about sort of stepping in if the original state who has the responsibility to deal with this is unwilling or unable. So I'm sure that the Israelis would come and say, we're doing what we have to do on these investigations. And here, just a final thing on the ICC before I close. So the families of Israeli hostages have recently visited the prosecutor, gave them, as far as I understand, documents and something that potentially could be used as evidence. That in itself is not a case, because anyone can submit, materials to the ICC prosecutor. So the prosecutor will decide if this will be a case or not. But indeed, this is something that we have heard has happened. So just to conclude and maybe say a couple of words that may be inspiring for the discussion. So the present situation clearly shows, I think, the limits of international justice. These limits are not new. A lot of these critiques we knew about, but it brings them in kind of really sharp focus. There's been discussions, and I think there's quite a bit of merit to it, about attention and resources and double standards, and are standards being equally applied to various situations in the world? I would say, and many would agree, not exactly. So for international justice in the broadest sense to be credible, it needs to be applied universally. And states that are key actors in this regard should be the one that we focus on, and courts maybe a little bit less. Because again, the ICC can't do anything if someone doesn't arrest a person and transfer them. I mean, they indicted Putin almost a year ago now. I mean, unless someone arrests him eventually somewhere, there's nothing that they can do, really. So they're really dependent on states. So these institutions are really as strong as the support that they get. These questions are also, of course, inherently political. So all of the stuff that we're discussing here, because the crimes are political. You commit, an act of aggression or genocide or crimes against humanity or war crimes because you have a political goal. You want territory, you want demographic changes, you have, access to resources that you want. Like all of these things are inherently political. So of course, we can't discuss this without in some way also touching on things that are deeply political. So, but the international justice system to fulfill the potential, its promise, I think, needs to be improved and not politicized or politicized less than it is politicized right now. And as imperfect as it is, it's the only thing that we have. I don't know if we dismantle this or if we refuse to engage with it, then I really don't know what we are left with. And just a final note, again, coming back to the very tragic and horrific situations that people are suffering. Ultimately, the ICJ, the ICC, or anyone outside is not going to stop the war, prevent people from dying. Ultimately, I think the solution will have to be a political one, but international law, I think, can provide some guidance about what is and cannot be the basis of that solution. Thank you.
Thank you very much, Eva, for a presentation that was informative and passionate at the same time. A rare combination. Thank you. So we're moving to the third and last presentation by Dirk and Jalvingh from Oxfam Novib. Dirk, the floor is yours.
Thank you very much. First of all, to start with a small caveat, and that is that I am not a legal scholar, nor am I a lawyer. I am a humanitarian. So if I'm slightly less exact in my formulation about the law, then please excuse me. But I think it's very important to talk about humanitarian law, and particularly also how it is applied currently in the situation in Gaza. So Oxfam is a humanitarian organization. We are present in the occupied Palestinian territory. We have 3 offices there. We have one in Jerusalem, we have one in the West Bank, and we have one in Gaza. We've been there for decades, providing mostly water, food, shelter, sometimes medical aid. Basically, the goal of humanitarian aid is to keep people alive, and that is the reason why we're there. So we have a small office in Gaza. We have now currently still around 30 people currently still in Gaza. They have all been displaced. They have all, many of them have lost their houses. I think nearly everybody has lost somebody that they know, family member, a friend. So one of the things that we as an organization definitely want to do also is to at least show what's happening on the ground. We have colleagues there who are witnessing these events. So also let them do the talking, let them do the speaking, and amplify the noise and the voices that they have. So actually, before I start, I wanted to share a short quote from a colleague who is currently in northern Gaza. I'm pretty sure that everybody's been following the news, but in the north of Gaza, that's particularly the part where food insecurity is at its height. Lots of people are literally starving to death, and this is one of my colleagues who is currently in northern Gaza. Today is another day here in north of Gaza, and I can guarantee that 99% of families here in the north cannot find anything to eat. You know what is hard and difficult? To find your children crying and from hunger, and you don't have anything to feed them. The markets here are empty, and you don't have anything to buy. And even if you do find anything, it is only rice, and it is too expensive. We still ask ourselves what we did as civilians to deserve the loss of our families, to deserve to live in hunger. And even if we do not die from bombing, then we will die from hunger. So that was from 2 days ago from a colleague. And that is, I think it's important to, we've been talking about humanitarian law, and sometimes it can sound dispassionate, but I think it's still important that the humanitarian law, one of the goals of humanitarian law is also to alleviate the suffering for the population, for the civilian population in times of conflict and war as much as possible. She is one of many people currently in Gaza who are suffering from this crisis. In total, there are 2.3 million people in Gaza. All of them are food insecure. And I think currently there are over 500,000 people in IPC 5. That means that they are in the highest classification of food insecurity or acute malnutrition. Acute malnutrition sounds still quite technical, but just to explain what it is, that means that these people are literally at the edge of falling over and dying from hunger. 1 out of 6 kids in Gaza are currently malnourished, and acute malnutrition, especially for, I think last Sunday there was an item on the news about babies being malnourished. That is such a severe situation that even, well, some of these situations, if you have a child that gets now into a fully stocked hospital and they get medical aid, then a significant part of them will still die from hunger. And even the ones that do survive, they will still be physically scarred for life. For children, especially the early phase, healthy food and healthy nutrients are important and enough calories. So if you don't have that, especially in the developing phase, that will affect your brain, that will affect your development. And so months of malnutrition for young children will scar them for the rest of their lives. So why is this important? And one of the things that Oxfam tries to do is to provide humanitarian aid for people. But for us, currently, it's very hard to do because we're being blocked by a lot of things, by a lot of factors. First of all, there's the violence, there's the ongoing conflict and the bombardments, which makes it very difficult to reach certain parts of Gaza. The north of Gaza is currently far too dangerous to work in. WFP last week, they had an announcement that they stopped working in northern Gaza, and WFP, the World Food Programme, is my primary provider of food aid in Gaza. So that's if WFP suspends their operations in northern Gaza, that's a very big thing, especially if that's where the biggest needs are. Also, access to Gaza, the border crossings are very difficult. That's also because of the Israeli authorities that don't allow humanitarian aid in all cases. Especially in the early parts, Gaza was completely cut off by a complete blockade, but currently also humanitarian aid is only trickling in, while far more is needed. I think a lot of people have probably seen the trucks lining up in the Rafah border crossing. Hundreds of trucks waiting to get into Gaza, while on the other side there are 500,000 people starving to death, which is, as a humanitarian, I have to say, that's, frustrating to say the least. And also a clear violation of humanitarian law to stop or blockade humanitarian aid. So that is, I think, for us, I think one of the key points that we want to provide aid, we want to help the civilian population and alleviate suffering. And according to humanitarian law, we should be able to access these people, but we're just not allowed to. A very clear example is that border crossings. Everybody knows the Rafah border crossing, but that's originally not even meant for humanitarian aid. It was only meant for pedestrians. The actual border crossing that was used primarily for humanitarian aid is on the other side. It's called RS, and that's still closed for us. So if we want to provide humanitarian aid, we've been sent from, kastje van de muur, from one side to the other and back again, having delays of up to weeks for humanitarian goods. Another example is the so-called judicial list. Certain items, if they're essential goods, then you can bring them in, like food things, for instance. But other things that are deemed less essential, tubes, for instance, for equipment that we need. A very clear example is that we currently are we're trying to provide 25,000 liters of clean drinking water a day in Rafah. We do that via desalination plants. That means that you can take seawater and desalinate them, take the salt out and make them safe for drinking water. That needs certain equipments like tubes and buckets, for instance, but not all of those equipments are being allowed at the moment, or with enormous delays. So that is, for us as a humanitarian organization, I think that is one of the key things why it's important that humanitarian law, that we talk about it also today, but also in general, that's why we as a humanitarian organization speak out about that. So I have 2 points. One is about what would we expect from the international community, and in this case, I think in particular the Dutch government. Because actually the Dutch government has long been known as quite a outspoken advocate for humanitarian law. They have actually quite good humanitarian policies, and in the past they have achieved quite a lot when it comes to humanitarian diplomacy as well. So one of the key things that the Dutch government has is their humanitarian policy. It was from 2019, and it very stipulates what the Dutch government does and should do in times of war and crisis. Right at the top of that list, you have a couple of bullet points, which are their priorities. But I think one of the key things that they said there, I'll read it, it's a nice quote. It says that in war, crisis, and conflict, the safety of citizens and aid workers is increasingly under pressure. In our humanitarian diplomacy, the Netherlands will appeal to the warring parties on the importance of strict compliance with humanitarian law, including granting aid organizations access to the affected population. The prohibition on attacking civilians and civilian infrastructure, including hospitals, schools, drinking water supplies, and homes, and the ban on starving civilian population. That's a very strong, on paper, it's a very strong policy. They actually also went a step further. In 2018, the Netherlands had a temporary seat on the Security Council. And one of the things they achieved was UN Security Council Resolution 2417 on the banning of hunger as a weapon of war. That was quite interesting because using hunger as a weapon of war against your enemies was a little bit vague before that time, but the Security Council resolution really solidified what it meant in practice and what states should do about that. So a quote by the then Minister for Foreign Trade and Development Cooperation: "The unanimous adoption of Resolution 2417 was a great success. But any resolutions are only useful if and when they are put into practice. Individual states must implement them. In the end, the child in South Sudan, the mother in Myanmar, or the hungry family in northern Nigeria has never heard of Resolution 2417. But they will notice if and when the international community takes action based on Resolution 2417. So I think that is quite a key point. Like, on the one hand, you have the international law, but you also need to have political will by states to implement that. So compare that to the situation we have now. I think in the past the Netherlands has been quite strong and outspoken, but compared to the situation we have now, it is, I think, quite weak. I will take a quote by the current Minister of Foreign Affairs, spoken in November, and I realize this is taking out of context, of course, but I think it's still instructive nonetheless. So in a parliamentary letter, she said the following: "A complete blockade of humanitarian goods is clearly in violation of Israeli obligations under international law, including the law of occupation. At the moment, only a limited amount of humanitarian aid and essential supplies are reaching Gaza. But determining whether there is a total blockade and therefore a violation of humanitarian law can only be done if the government has all relevant facts. Given the unclear situation on the ground, the government does not have sufficient facts to determine that there is a complete blockade." I think if you compare that to the statements in the past about how strong they were, I think there's a very clear discrepancy. And especially they've used this argument also in the F-35 case that we've been working on, that they're saying that they don't have the facts on the ground. But they also, in my opinion at least, seem unwilling to ascertain those facts. Because you have several humanitarian organizations on the ground, including Oxfam, that have had conversations with the ministry. I've had meetings with the minister, and my director has a meeting with the prime minister even. And we've said to them, look, this is what we're facing. We're concerned about humanitarian aid not getting in. We're concerned about violations of humanitarian law. This is what's happening on the ground. But for some reason, that is not enough of a trigger for the government to take action in this regard. And to put very bluntly, I think it's almost a bit like the ostrich method, to put your head in the sand and go like, okay, I don't see anything, I don't have the facts on the ground, and therefore I don't have to take action. Lastly, the court case about the F-35. That is more related to arms exports in general. And I think in that regard, the Netherlands in the past was also quite a strong actor. There are several important international treaties about arms exports. There's the Arms Trade Treaty, which the Netherlands actually was one of the countries that was pushing for that in the past. There's also the EU common position on arms exports. And, well, one of the things that these international treaties have in common is that they say that if there is a significant risk that weapons that you will export will be used in war crimes, then you shouldn't export those weapons. And if you have an ongoing permit and the situation changes, then you should look at the situation again and see if those IHL risks are still there and take action based on that. That is quite, on paper, still, again, quite good. If you look at the website of the Ministry of Foreign Affairs, I looked at it today, they say the following about the Arms Trade Treaty. The Arms Trade Treaty is a global arms trade treaty adopted in the United Nations. The treaty regulates the international arms trade. This prevents the use of exported weapons in genocide, crimes against humanity, or war crimes. The Netherlands played an active role in the establishment of the Arms Trade Treaty. The Netherlands ratified the treaty at the end of 2014. So on paper, they have quite a good policy. But again, we had meetings with the Ministry of Foreign Affairs on numerous occasions. But somehow there was like a very big gap between what we were saying and what they were hearing, in my opinion. So we, together with Pax and the Rights Forum, the three of us, we started a court case, not because we wanted to, because it's really like the last option that we had to make sure that the Dutch government does the right thing, in our opinion. So we did actually nothing that's the only thing that we wanted from them, the only thing we were asking for is for the Netherlands to adhere to their own policies, basically, to their own points that they made in the past. So yeah, it was quite a complex case, and I think we were quite happy with the outcome, but it was still also disappointing that it took literally months of conversations and the court case to get to a point where the Dutch government had to abide by their own obligations under IHL, in my opinion. Yeah, so I think my conclusion so far is I think humanitarian law on paper and humanitarian policies, I think on paper they're quite good, but I think the point where it falters, I think, is the political will to actually implement them in practice. And I think, so I was recently in a conversation with a journalist and she asked, do you need another resolution? Do you need more laws, for instance? I said, no, just implement the ones that you have now. And I think that was the conclusion for so far. Thank you.
Thank you, Dirk, for bringing your very important perspective to the table here. Now, the floor is open for questions to our speakers, so you may raise your hand, and when I will give you the microphone, you can also say if the question is addressed to one specific speaker or to all of them, or to whoever wants to respond. So are there any questions? Well, that's 1, 2, 3, 4 for now. I will take this 4 for now. I will hold the mic, if you don't mind. I like doing the journalist.
Yeah. Thank you very much. It was a very nice presentation from the three of you. So there was a mentioning of political as something negative or something to avoid to some degree. And my question is how politics, and not only the political concept within the context of states, but really in the context of civic engagement, has played a role in all this uprising of court appealings and discussion, because that has an influence on how we react to the conflict and what would be our position. From what I heard, now in my perspective, it feels like I shouldn't engage in politics, or everything is too political, so I should avoid it. But on the other hand, that's what makes you take a stand and actually hear to what law has to say and where to stand based on the law as well. So yeah, I'm curious to hear your thoughts on that.
You? Is there anybody who wants to answer this or feels strongly about this question? Was the question directed to anybody in particular? No, okay.
Do you want to collect a few, or do you want to go one by one?
Maybe we can go one by one, yeah.
I can start. Just, I think when we think about political engagement, I would say if we care about these kinds of topics, and I think for all of us here we do, otherwise we wouldn't be here, I think it's incredibly important to be informed and to make sure that you make your voice heard. Of course, some people think of it narrowly as in voting in elections, but it's not only that. For example, we can take one example from the United States, where they're running the primaries now, of course, so the situation is quite tense. Depressingly, we have the same two guys running that we had last time. But in Michigan, I think there were primaries, and the opposition in the Democratic Party to Biden's policy in relation to Israel and Gaza has resulted in something like over 100,000 people not supporting Biden in a way that maybe otherwise they would. And that's, I think it was a campaign to send a message, and I think that message has been sent. So I think that, methods of political pressure, I think, are incredibly important in various kinds of places, universities as well, of course, within the limits of the law, of course. But I think ultimately we can do what we can as citizens to try to pressure our government. And I think to a certain extent it also speaks to what you were saying as well about implementing the policies that they already have. So it may seem imperfect, but again, what else are we supposed to do?
I'll take a second question. There was someone in this zone, yes.
So my question is related to the notion of intent in the humanitarian law, or in the genocide law, I think in this case. And my question is whether, seeing that, for example, you mentioned that we have 500,000 people at acute risk of death by starvation, whether there are any laws where it makes more sense to just look at the effects and not at the intent.
Still for you, Eva.
Yeah, sure. So again, speaking more as a historian that's been hanging out around courts for 20 years than a practitioner lawyer, I think for people outside of the legal world, it would make, of course, sense. And many people have this gut reaction, you know, X, Y, Z number of people have been killed. So of course it's a genocide. But strictly speaking, it doesn't really. I think one way in which we've seen intent in cases of genocide, for example, proven, and I can speak mostly to cases from the ICTY, the Yugoslavia Tribunal, where I used to work, are, for example, political speeches that make clear references to intentions to remove a certain population. That is then combined with information that, you know, in case of Srebrenica, for example, we've had 8,000 people shot in a matter of weeks after the 11th of July, 1995, and dumped in mass graves, you know, as if they were trash. So those things are then combined, but the fact that people are dying of hunger in and of itself does not prove a genocide. And then many people then critique, well, then this law is, you know, it doesn't work, it's not good enough, and that's a fair critique. Many people have made it. But as it stands, the fact that people are dying of hunger, even in, you know, hundreds of thousands, is not in itself, unless we can prove that someone has sent a memo saying, stop all supplies going in, we want them all dead. That would maybe, but no one is stupid enough to write that down.
Can I maybe clarify? Yeah, so just to clarify, I didn't mean the genocide law itself, but asking whether there are other laws not related, not related to what constitutes a genocide.
Yeah, maybe I can add. Well, let me quickly add one thing on the genocide intent, because as Eva correctly said, you have to be really stupid to write down in a memo that your intention is to kill a particular population. So what courts will do, they will look at the facts, at other circumstances, and the standard that's used is that they will find that there was intent to commit genocide if that's the only plausible inference from the fact. So that's a very high standard. So you don't need the memo, but it sure will make your life much easier if you're a prosecutor trying to prove that there was genocide. So that's about genocide. Also in IHL, or to be more specific, in the law of war crimes, there are the intent is often an important element. So, for example, the war crime of attacking civilians is about intentionally attacking civilians. So, before the International Criminal Court, for example, if there would be a case about or including attacking civilians, then the prosecutor would have to prove that this was done intentionally. And the same goes there. Although I don't think necessarily the standard would be quite as high as in the case of genocide, but it will be much easier if there's somehow something on paper or an order that was intercepted. But even without something like that, based on the facts and the circumstances, there could be a conclusion that yes, there was this intention.
Thanks for the talks, very informative. I have a question for Marten. It's a legal question, weapons. You explained the case, the Dutch court ruled against supplying these 535, pieces for maintaining the aircraft. Now I wonder if there is a possibility of a legal case in the situation of knowledge institutions that have linkages on transferring knowledge with a state such as, Israel or even Russia, whatever, you name it, in the same terms, or if that legal case will be very difficult.
Well, I think that would be very difficult. Of course, the case before the Dutch courts on the F-35 parts was a case against the Dutch government, which had provided a license, or rather had not withdrawn a license. So there, you could say the Dutch government has certain obligations under its domestic legislation, which implements its international obligations. If you talk about knowledge institutions, first of all, I think in many cases, well, they may be sort of part of the government, but they need not necessarily be. So then it will be much more difficult to invoke obligations of the government. And also, I think it will be much more difficult because probably the link between what knowledge institutions do and the harm that may ensue in Gaza, for example, will be much more indirect in most cases. But I don't. What is interesting is that we talked about international courts, and actually sometimes it's much easier to go to domestic courts, as I think the F-35 case shows. In particular in the Netherlands, there are quite a lot of opportunities for individuals or NGOs to bring a case against the Dutch government or against others under torts law. So I don't totally exclude the possibility, but I think it will be very, very difficult.
There was a fourth question here, and then I will take another round of questions.
Hi. So there was a discussion on the definition of hostages and how there was also a ruling later describing, defining it clearly. So with those legal, more clear definitions now, let's say, would the prisoners in Israeli jails who are from occupied territories, would they be considered hostages?
Well, it would depend on the easy answer is it depends on the facts, but it would that at the end of the day that is the case. So if they were used to try to compel a party to the conflict to do or abstain from something, then that could be the case. Of course, Israel will say no, they are terrorists and we're preventively holding them as we are allowed to do under IHL, or they committed a crime and we're going to prosecute them.
So I will take another round of questions. There was 1, 2, 3, 4, 5, 6, maybe 7. Let's see how it goes. One was in the back here. Maybe I will take all the questions together, and then you guys will try to juggle and answer as much as you can.
In relation to intent and what you just mentioned, there is a concept floating around that international law, essentially in these asymmetrical warfare scenarios, does not have a accurate or even workable definition of what a citizen is, or a civilian essentially, because a lot of countries do claim the civilian could at any point of time be a terrorist or not, and it becomes very muddy in respect to that. Do you see any movement on that? Is that becoming any clearer, or are there implementations being done, or is it just ignored, put in the wayside? I don't know.
Thank you. Take notes. I'll go wrong.
I also wanted to follow up on my neighbor's question on the whether they're prosecuted, like the Palestinian hostages, because it is known, right, that they are taken under military law in courts instead of civilian courts, and also there are many cases that they haven't been prosecuted. So what are then the definitions of a hostage? Is this like a kidnapping scenario almost, or if they're not prosecuted at all?
Thank you. Sorry, I lost track of the hands. Please, no new hands. I will swan it back here and then come your way.
Thank you. Thanks for the presentation. It was very informative. My question is towards Marten. I am asking about an incident that happened before October the 7th and the attack. So this is on respect to the peaceful protest where people in Gaza were marching. It was termed as the Great March of Return. And a lot of people were killed there, including journalists. So would this constitute as an international humanitarian law breach? And if so, why has nobody or Israel acted with impunity on this topic, and why is it not being voiced out? Why are most of the conversations starting from October the 7th?
Thank you.
Do we have questions for others?
Sitting next to you.
Hi, thanks for the nice talk. I have a question on misinformation, because I think there was a lot of discussion about misinformation, fake information, and I was wondering first how you, maybe especially as a historian and a lawyer, deal with misinformation and what you can recommend for us also, because I've heard this argument within discussions that people refrain from political action or refrain from commenting at all because they say, oh, it's so hard to know what's even going on, and yeah, do you have any recommendations on that?
Thank you. Was someone else here since I'm here?
You mentioned that it was that it would be that no one is so stupid to write in a memo like, yeah, we want a full siege and that thing. But during the International Court of Justice hearings, I think they South Africa spent about 20 minutes of these quotes, including this one from Yoav Gallant, which is, I have ordered a complete siege on the Gaza Strip. There will be no electricity, no food, no fuel. Everything is closed. And so does that not qualify as that specific intent? And if I may, a second part, which is about the hostages. They were asking about whether the hostages in Israel, the Palestinian hostages in Israel, would qualify as hostages. And you said, what about the facts? But there are hundreds of administrative detainees who do not have any charge and do not have any lawyers or right to talk with family. Can we not consider those to be actual hostages?
Thank you. I think I've collected 4. There were 2 more. One here. One here.
Thank you so much for your presentation. I have a question regarding the occupation. How the international law consider or perceive the occupation as a sort of violence, and what are the consequences of that? We can see that how the international, say, community condemned Russia, but Israel has been occupying the West Bank, leave Gaza aside, for almost 50 years or more. So how the international law deal with that?
My question is to Dr. Iva, just to boost on his point regarding the intent. I think a few months ago, before October 7 as well, there was a map shown by the Prime Minister of Israel where he did not show the parts of Palestine in the map. Which, in my opinion, or in general, like if anyone sees it, it clearly shows that you don't want those people in that area, which can be classified as genocide. So, how would you explain that? Just to boost upon his points.
Thank you very much. I think I've taken all of the questions that I promised to take for now. I will add a bonus question to Dirk, Jan, since all of the questions were for most of them. I go back to where we opened. What are our responsibility as students and teachers in public universities? And so you mentioned this gap between the policies, the laws and the policies and the application. So what could and should be our role as professors, students of this university? Folks, you have 20 minutes. Good luck.
Shall I start? I think most of the questions were addressed to me. So, a very good question about civilians and as what is the civilian comment or pressure in how conflicts have developed, and terrorists and asymmetric conflicts and fighters not distinguishing themselves from the civilian population. I think the concept of civilian in principle still stands, and from a legal perspective, there's still a clear distinction. It's a different matter whether it's always clear to determine whether someone fits in one category or not. So that's a more practical question. And thank you for asking that question, by the way, because this was something I was giving a tutorial on this morning. And then in the afternoon, I talked about the protests in Gaza in 2018. So you were reading my mind, it seems. So, without going too much into detail because of the time, but they're under IHL, as I said, civilians are protected, but there's a but, namely when and to the extent that when and for as long as they actively participate in hostilities. And there's no definition of what that means in IHL treaties. A number of years ago, the International Committee of the Red Cross started a process to try to clarify what that means, and at the end of the process they published what they call an interpretive guidance, which gives more body, but not everyone agrees with the criteria that the ICRC provides. So that is, I think it's clear who's a civilian, but there is certainly debate about what are the exact criteria for when a civilian loses directly participate in hostilities, which is very important because the consequence is that person can then be legally targeted. So I didn't have a pen here, so forgive me if I miss a question, and I'm sure you'll remind me. There were I think 2 questions about the protests in Gaza in 2018. Or 2 questions about hostages, sorry, or persons detained by Israel. I personally would not really come at that from from hostage taking, because as I said, I think it's debatable whether Israel is holding these people to compel someone else to do something or not. But I will say that there are other rules of IHL that play a role. So for one, if you accept that Gaza, and certainly I think no one disputes except Israel, that the West Bank is occupied, then there's an obligation under the law of occupation that you cannot bring persons who live in the occupied area outside of that area. And of course, if Israel, which in many cases happens, arrests people or captures people in the occupied areas and then takes them to Israel to be detained there, then that's problematic under IHL. Even though under IHL, it's in international armed conflicts and in occupation, it's allowed to detain people without bringing them to trial because they form a threat to the security of the occupying power. But I think the one of the problematic aspects there is transferring these people to Israel. Other problematic aspects include one that was mentioned, is certain fundamental guarantees that these persons should receive in terms of their treatment and in terms of how they're dealt with procedurally. And then there was a question about the Gaza protests in 2018, 2019. And there, the question was, is that problematic under IHL? Was IHL violated there? The UN and UN experts, among others, have been very critical of that. Although a question could be, should we be looking at humanitarian law or should we actually be looking at human rights law? Was this more like a law enforcement operation by the Israelis to try to prevent people from crossing the fence? But certainly the direct targeting of protesters, many of which seem not to have been a direct threat to the Israelis, are problematic, whether it's under IHL or under human rights law. And then I think there was one other question for me, but now it escapes me.
International law of occupation. What is the international?
Yes.
Yeah. The big one.
Yeah. So there are 3 criteria for a territory to be occupied. There have to be military forces that are present in another state's territory without consent. They have to exercise effective jurisdiction, effective control over that area, and because they do so, the original authority in the occupied territory has to be prevented from doing so. And it's a factual determination whether or not there's an occupation or not. And then your question was, it now comes back to me, whether we can say that that's unlawful or not. So under humanitarian law, under the law of occupation, that's not really a question, because the law of occupation starts from the factual situation of occupation, and then it gives certain rights and obligations to, or mostly to the occupying power, but it doesn't say anything about the legality of the occupation as such. The rules that are relevant for the legality of the occupation as such are more in the field of the international law and the use of force. So there, in the case of Gaza, for example, we have a live question whether Israel is allowed to use, has the right to self-defense, and as a consequence, it would be allowed to occupy parts of Gaza on that basis. And also, I think Eva mentioned it, the law of self-determination, whether an occupation would violate the right of self-determination of Palestinians, which actually in 2005 or 2004, in the Wall Advisor opinion, the International Court of Justice held that it did.
To Dirk?
I think there's a potential follow-up if it's
Potential
allowed.
follow-up. If it's really quick, like I will count the seconds.
And how about building settlements on occupied territories?
Yeah, so that is a question of IHL, and that's I referred to the prohibition of moving inhabitants of the occupied territory outside of occupied territory, and part of that same obligation is the prohibition to move your own population into occupied territory. So there's broad, if not universal consensus that Israeli settlements are in violation of international law.
Okay.
Yeah, and thanks for the additional question. I was actually very happy that most of the difficult questions were aimed at my neighbors here. But to answer your question, I think what should students and teachers do? And I think one thing is exactly what you're doing, to talk about these sorts of things. And I think you're doing this in a very respectful manner, and I think that's good. I think it's good to inform oneself and to broaden one's perspective, but also to talk to people who might have a different opinion. And I think the one thing that, as far as I know, at least a lot of people agree about, is that international law is like the law is like something you see each other as a human being, right? And the more you talk to one another as a human being, the more you also understand one another. So I think that's important. But also to speak out about politics, I really think people should not be worried about speaking about politics. I think it's actually very important to speak out, let yourself be heard, but also to keep your own representatives accountable for what they are supposed to be doing. I don't know if anybody here is a member of a political party, but I would highly recommend looking up on their website who's their spokesperson for foreign affairs. And if you have an opinion, send them an email. Usually you can find their email on the website of either the political party or on the tweedekamer.nl. So it's very easy, and I would highly recommend doing that as well. And lastly, I think it's also good to see what's happening in terms of petitions or organizations that you feel that are doing a good job. And there are loads of petitions or methods and ways to speak out. So yeah, I would definitely recommend not sitting still, but definitely going out there and letting yourself be heard.
Thank you very much. Were there any other questions for you?
Not as far as I know.
Okay, good. Eva.
Yeah, I can. First, I'll start with the questions about the speeches. Now, of course, I've watched both proceedings literally the entire time. I've read the application that South Africa submitted, so I'm familiar with the quotations. What I want to emphasize here is that I deeply feel it's not my place to say if this is a genocide or not. And one of the reasons why is because I speak neither Hebrew or Arabic. And there have been questions raised. I don't know if you've been reading in The Atlantic, for example, from a staff journalist in The Atlantic who does speak Hebrew, who says that in the translation that were widely circulated, some words, some important words were potentially omitted. I am not in a place to listen to the original and make that determination. I can't read or hear the entire press conference, so I will be waiting for the court proceedings to happen, to have professional translators and interpreters discuss this. And I'm sure it's going to be raised in court, and Israel has raised this in court. So what I do feel is a strong reservation of coming out and saying this is indeed an evidence. if they are authentic and if these statements truly are translated and checked the way South Africa has presented, then I have no reason to doubt it, but there have been questions raised. Then I think they are highly indicative. For example, the human animals quote and the cutting off of gas, water, electricity, and such statements definitely would feed into a plausible case. If I was a prosecutor, I would use those statements too. And similar statements have been used, for example, by Radovan Karadzic, the Bosnian Serb leader, to prosecute cases in Bosnia and Herzegovina. It's just that at this moment, as a person who doesn't speak either of the two languages, I feel a strong reservation to having strong feelings about what the precise claims in those statements are. But indeed, the South African representatives, but also the written application, which is also available on the internet, so you can read it yourself, does speak to these. And that also brings me to the question about information and misinformation, which I think is really, really relevant in the context of this, but also, of course, not only this case. I think it's very difficult in an era where we are in a position to access incredible amounts of information, and yet we are often siloed within certain conversations. It's difficult to have a sense, is that everything that I'm hearing factual, and who are the sources that I should be following. I think one recommendation generally is to cast your net broadly, so try to not read only the things that we already agree with, and not to hang out only in, I'm not sure who's still on Twitter, but because that of course tends to feed into conversations that we're already having where we are not hearing other arguments. But one rule that I have for myself, which is, if I have really strong feelings about something, I am extra careful about what I'm reading, because whatever I read feeds into my existing strong feelings. So I try to, and this is again going to be offensive to some of you maybe, but I try to really keep as distant as I can. And I of course know that that's a privilege and a luxury. But I think there's benefit to that, to keep an arm's length for those of us that have that luxury, that don't have family there, that don't have strong personal ties, to try to remain aware of yourself and your own thoughts that are kind of the playing field onto which these messages land. And I would say, again, referring to maybe the outdated Twitter, that if I feel things very strongly, I put the phone aside. That's my rule number one. If I'm burning up with something, maybe this is not the time. Maybe tomorrow morning is a better time to respond. To just, I guess, a little bit kind of break in some way. No one is going to out there, suffer greatly without my tweets. So I think it's important to try to the extent that it's possible, and for those of us who have that luxury, to keep a bit of a distance and to try to cast our nets widely and read things that you're not naturally inclined to read. I think that's a good recipe.
Have all questions been answered? At least the one that we took. Is a follow-up on the question?
Probably it's a historic question, because you referred to the Nakba in 1948. My question, after almost 75 years, why this event? Because you referred to it, and it's a fact. The mass disposition of indigenous population. Why this, let's say, tragedy hasn't been condemned or even admitted internationally?
Well, I think it depends a little bit, because, of course, there are some actors who both recognize it and condemn it. So I think it's generally really difficult to speak about something as its international community. It's such a vague, we also tend to, I think when we see about the international communities, some parts of it will recognize and condemn, some other parts of it will ignore, some other parts of it will celebrate, some other parts of it will have no idea what Nakba means. So I think it's very difficult to speak in general about the international community. Again, just to bring back things to this sort of sense that ultimately a lot of this is about politics, it's about domestic politics, it's about elections, it's about alliances. And, there's other cases of historical crimes, colonialism, slavery, and a bunch of other violations throughout sort of human history and even contemporary human history that remain largely unpunished, unrecognized. There's no reparations, there's no a sort of a remedy for historical injustices. So I would say this is an example in one such situation where there has been no, credible, I guess, legal response or even political response to that dispossession. I think it comes down to politics.
I would take two more questions, and sorry, we don't have time for a second question from the same person. So, do you guys think you can make it in 15 seconds each? Okay.
For you in the middle, you thought that humanitarian aid is to go to keep people alive. Is there anything you do more to keep them alive, or is it just merely keeping them alive? And how do you feel about that if that's the case?
My question is, I speak difficult because I had a stroke, but on the 7th of October there was an event, and all the people in the world, the prime minister or the Netherlands and main media, they speak that Hamas make horrible events, but nobody here what Israel did in the killing itself. Many victims were already killed by Israel. I think so. I did read it. And maybe you can, Eva or other one, can respond to that.
Okay, I think these were the two last questions, Dirk and the other.
Thank you for your question. And I think humanitarian aid is never a permanent solution. I think humanitarian aid is only on the short term to keep people alive. That's very true. I think as Oxfam, as soon as more is possible, we also do development work. We also try to help people to escape poverty. We also try to rebuild if possible. But for the moment, nothing like that is possible. You only need to worry about people getting like the first essential basis and goods. As soon as more is possible, then yes, of course. We also had in the West Bank, for instance, programs for helping people set up agriculture and farming, for instance. We also had programs on women's rights in the West Bank, which was also interesting. But yeah, you do only what the situation allows you to do. And if people are starving to death, then the only thing you can do is like immediately aid. But as soon as more is possible, then you also do more than that. Yeah.
And just on the last point, maybe, I think it's just a reminder that this is a place where we are witnessing a cycle of violence where there's historically really dire need for a sense of justice and sort of political solutions and reparations. And I think this is really a time and a place to try to figure out how not to keep sort of, having these violent events and then responses to the violent events and then some more violent events. That's, I guess, the only thing that I can say to that.
Ladies and gentlemen, for what matters, I enjoyed this event very much. So I hope everybody has enjoyed at least as much as I have. Thank you, Camilo. And so, first of all, a big thank you again to Studio Generale Marike for organizing this and all the team, also the technicians in the back. Thank you very much. And the ESP for supporting this big room. Thank you, as usual. And thank you all, first of all, for the very respectful and passionate at the same time discussion. So I really appreciated the way we managed to spend 2 hours discussing these uncomfortable and sensitive but super important topics. And most of all, thank you very much, the speakers, again, for being with us. Thank you.